All right, so let's take a look at this plea agreement that was signed by Lane with the prosecutor. Has to be approved by the judge. If not, then this deal doesn't go anywhere. That's part of the deal. So Dummy Kruger, of course, came up with this, so all the credit goes to him. I just want to comment on it very briefly, and then we'll move on. So he pled guilty to a Class 5 felony, which was stalking, and then a Class 6 felony, aggravated harassment. The aggravated charge comes from the fact that he had a prior order or an injunction in effect against the same person. You violate it, and so now that's aggravated. Aggravated anything is bad in the law. I think you can tell. So we got what is here are possible sentence ranges. Now the defendant needs this for due process and also to avoid unfair surprise. You don't want to leap into signing this only to find out that you're going to get effectively the same sentence you would have got at trial anyway. And you have to serve at least 85% of your sentence, similar to federal. The minimum sentence, which would be that the judge can just issue right off the books, would be 1.25 years. So what, 1 year and 3 months. Mitigated would be even less than that, and there would have to be a very good reason for it. And the good reason would be, let's say, let's save the taxpayers a lot of money having to plead, say, 20 charges. He cooperated, he made restitution. On the opposite is aggravated. What things were done that would cause the court to say, you know what, not so fast? For example, does he have prior convictions? A lot of different things. It all kind of goes in the hopper, and then the judge kind of says, well, from there, this is what I'm going to give you. So right now, the minimum would be 1 year and 3 months. Maximum would be 3.5 years. So by signing this, absent mitigation and aggravation, he's looking at, 2.5 years, not counting the credit he would get for time served and for good time credits, whatever. Now, we don't know what the DA has said about maybe just going for the minimum sentence of, and then he would maybe get several months, maybe 8 months. It says upon the completion of the prison sentence, the defendants will be placed on community supervision. Now here, it mentions that the probation for a class 6 felony is 3 years. I didn't see what it said for class 5 because the form is cut off. But if it's 3 years and, do they string it together with, say, the other one, let's say it's 2, now it's 5 years of probation. Here's the danger of probation. You can get in trouble again. You can violate probation, fail to report, fail a drug test, whatever it is. Not be gainfully employed, whatever it is. And you can be back in front of the judge for additional time. So that's why probation is dangerous. This blows my mind. The court may require the defendant to pay a fine of $150,000 and a 78% surcharge, which would be like another $118,000. What the heck is that all about? Man. And then here, this is basically special terms of a lifetime ban. Does not expire as valid for the defendant's natural lifetime unless dismissal is granted pursuant to this. That might be a basis for them now seeking a much lower sentence. Restitution is a big problem here if it's the $270,000. Really, to me, the big thing right now is this fine. And then failure to pay a fine can be a violation of your restitution obligations under probation and put you back in jail again. How do you pay it if you're not working? These are problems, guys. And then all the standard waivers. Oh, yeah, it says advisory council right here. This is what I see that usually happens. The person is acting as their own lawyer, so they're already at a big disadvantage. Secondly, they're trying to deal with all these charges and they've got to figure out how to get evidence. Next, they're making statements along the way that are going to be used to convict them. And when we're talking about auditors, they have a propensity for filming everything and putting it up on their channel. And that's what's always used to bust them. If you don't have high-end legal talent, you already come in at a really big disadvantage. And if you represent yourself, you're at an even bigger disadvantage. So that's all I got for now. Catch you on the next one.